Welcome back. For anyone just joining us, my name is Bryden DeWitt, and I am a partner in our employee benefits practice. I focus my practice on all areas of employee benefits law, including qualified retirement plans, health and welfare benefit plans, ERISA fiduciary duties, and benefit issues arising in mergers and acquisitions. Now I'd like to welcome Jim McLemore and John Faber. Jim McLemore is a partner with our finance and real estate section with more than 2 decades of experience advising commercial and business creditors, landlords, vendors, indentured trustees, banks, and credit unions in bankruptcy and insolvency litigation matters nationwide. She frequently represents clients in matters involving post petition contract and lease negotiations, disputes involving asserted claims, financing issues, and other distressed asset matters. She also represents clients in bankruptcy litigation situations involving avoidance actions, claim objection disputes, and dischargeability claims. Jen serves as a Subchapter 5 trustee in smaller business bankruptcy cases throughout Virginia. John Faber is also a finance and real estate partner here at Williams Mullen. In over 3 decades of representing lenders and borrowers, landlords and tenants, developers, investors, owners, brokers, and managers, John has built an expansive finance and commercial real estate practice. John guides clients through every phase of the life cycle of real estate and financing transactions, including workout, restructuring, and foreclosure. The property sectors he works in literally cover the waterfront and include marine terminals and other riparian parcels, hospitality, office, industrial warehouse, retail, mixed use, single family, and multifamily residential, as well as vacant land. With that, I'll go ahead and turn it over to Jen to kick us off.
Thank you, Bryden. So I think we're all here to listen because we know that real estate investments are distressed and we want to know what to do about it. I'm going to touch briefly on the why, but I think we are all probably aware of the fact that interest rates, global stressors, changing insurance obligations and rates, the lack of inventory for homes, the excess inventory for office, and then you have an election uncertainty are just sort of the beginning, the tip of the iceberg. I promise I will not give you the full list of things that are keeping me up at night. Last year had a similar list. It may have had different things, but it was also long. There are lots of headwinds in the real property space. The common denominator here is that real estate is still in distress. We may have a different reason. There may be a different source of the stress, but there are things that are changing, but that are not necessarily changing the way we perceive real estate as an asset. We are definitely, as a society, still trying to figure out how COVID fundamentally changed how we're using office and even retail. I can do a heck of a lot on my phone and I can work remotely. I can work from anywhere. That changes whether or not we need retail and real estate space as we have traditionally used it. And it's not news, but it's time for us to have a game plan. When we are talking about distressed real estate, we need to stop talking and start either making a plan to get this distressed real estate off of the books or redevelop it or do something. It's interesting, even this morning on the news, there was a back to office segment, and it was talking about back to office not necessarily being a way to get people back to office, but getting people to move on to different jobs. So even when people are pushing for back to office, it may not be upping our occupancy rates in real estate office. Next slide. So there are some normal distressed real estate remedies that you probably have all heard of before. I'm going to tick through these fairly quickly because they think they provide context for the rest of the discussion we're going to have today. Foreclosure, for example, is a bank exercising its rights and remedies when a borrower has stopped making loan payments on real estate. There are options in some states to proceed under judicial foreclosure or non-judicial foreclosure. No matter what, in some, we are exercising the rights under a deed of trust and a mortgage and the governing state law. Receiverships are an opportunity for a lender to bring in a professional person who knows how to run the borrower business. They can run it until a sale process, and they can run it until some other remedy is put in place. I've done receiverships when someone stops keeping a manager on site, or when they're no longer providing insurance, and those sorts of protections need to be put in place for the bank. Assignments for the benefit of creditors are a little bit more like a borrower crying uncle. They are no longer going to try, and they're going to hand the keys to the business over to the borrower. It's a structured way to do that. Refinancing, we all know what that is. You've got to have better interest rates or something to make refinancing worthwhile. Forbearance agreements and kicking the can can probably be put in the same category, where the bank and the borrower are cooperating in one way or another. Really helps when a borrower has new leverage, a new guarantor, or new collateral, or something to give the bank a reason to negotiate with them. And then bankruptcy. And bankruptcies can take any number of forms these days. You may have heard of a prepackaged case. That's when all the work of the case is done before the filing, and they can be done in, I think the fastest is 45 minutes. Single asset real estate cases, which really are what they sound like, where a borrower has one single functioning piece of real estate and they put just that into the bankruptcy. A reorganization, we all know what that is, and a liquidation, whether it can be sold in pieces and parts or everything together, that is what that remedy is. And then subchapter 5 is a new one. We won't get into the weeds on that, but that's another option for smaller businesses. So next slide. The purpose for today's presentation is really to address something that a lot of those remedies that I just listed don't have a clean and neat way to address. Real estate can have equipment on the property in the parking lot. It can have stacks of rocks or coal or other things that are collateral. And just selling the dirt or running a foreclosure process doesn't necessarily provide an easy remedy to deal with that collateral. And so we're really here to talk as much about, if we're liquidating, what do we do with the stuff that is there on site? Whatever the debtor or borrower's business is, we need a way to address, liquidate, value, and handle the actual furniture or equipment or vehicles that may be on site. And one thing that is very true in the bankruptcy context is that when you can sell a turnkey operation, you generally are going to get more money for it than if you're selling off, each pot and pan in a restaurant. If you're selling a going concern. And so actually having an understanding of these Article 9 concepts that John's going to cover in great detail can be really helpful for putting together a turnkey sale. So as Braden mentioned, we are doing poll questions today. So we're going to just start with a quick poll now before we get into the meat of Article 9. So our question is on the screen. Do you think there will be a true recession during 2025? There is not a right or a wrong answer. I think we're just as interested in making you guys think. So please, if you want credit, respond. We're not trying to hide the ball, so it'll be sitting there for a minute. I cannot see whether or not people have responded, so I think it's okay for us to move on. And John, I'm gonna, oh, wait, I can see. Let's see. 25% of you think that there will be a recession in 2025, 64% say no, and 11% say we are already in one. All right. John, I'll let you take it away.
Thank you, Jen, and thank you, everybody, for joining us today to talk about successful enforcement of a security interest under Article 9 of the UCC. Before we get started, a quick word on the UCC. Everybody knows that the U stands for uniform, and in most of our jurisdictions, that is correct. The provisions that we're going to talk about are the same, but variations do exist. So when I mention a provision in here, please remember to do what they tell you to do on television and check your local listings. So let's start with what is available to a secured party to enforce under the UCC. The remedies primarily appear in Part 6 of Article 9 of the Uniform Commercial Code, and the laundry list of what that provides. It starts with the secured party, in the event of a default, can reduce its claim against the debtor to a judgment. The next thing it can do is foreclose. Foreclose means dispose of in UCC parlance, and that is by far the most frequently used remedy. So we're going to talk about that in detail in a few minutes. The secured party can enforce its security interest by any other available judicial procedure. Sometimes maybe specific performance, sometimes maybe injunction, declaratory. The secured party next can notify any account debtor or party liable on the collateral to make payment or render performance to the secured party. That's the situation where the secured party's collateral includes the debtor's contract rights. It includes notes payable, accounts payable to the debtor. In the event of a default, a secured party can contact the third parties who are liable to the debtor on those instruments and say, now you pay me, now you start rendering performance for me under that obligation. A corollary of that is that the secured party can also enforce those obligations against that third party. If the debtor is delinquent or lazy or refuses to enforce its own rights against its own counterparties, the secured party who has a perfected security interest in those rights can go to the third party and enforce and make them pay or perform for the secured party. We'll move on to the next slide, please. And the next remedy that's available to a secured party is to apply the balance of a deposit account that is secured by control to the obligation that's secured by the deposit account. And the next one that we will discuss, which is kind of a rare one, is called, in ordinary parlance, strict foreclosure. The secured party can accept the collateral in kind in full or partial satisfaction of the obligation. It's kind of rare, and the secured party has to jump some hoops to do that, and we'll talk about that a little bit later. So it doesn't really happen that often, but it's available. And then finally, there's a catch-all in Article 9 that says the secured party will have other remedies as provided in the security agreement between the parties. So the secured party needs to know what those remedies are, and what's available to it, and what fits the secured party's goals and aspirations the best with respect to enforcement. In order to start enforcing and have a successful enforcement, if we could move to the next slide, the secured party needs to lay the foundation for that in the loan documents, and in particular in the security agreement. In drafting a security agreement, a secured party shouldn't just rely on platitudes like, in the event of a default, we're going to have all rights and remedies under applicable law. That is because applicable law in that case is Article 9. And as we'll see as we go forward, Article 9 is not always very forgiving to the secured party. So you want to adjust those in your negotiation and drafting if you're a secured party to the extent that you can. Be mindful, though, as a secured party when drafting, that Section 9602 of the UCC prohibits certain provisions from being waived or varied by the obligors. The secondary obligor, meaning a guarantor, or the debtor, the party that provides the collateral. A secured party that inadvertently makes somebody waive or vary something that they are legally prohibited from waiving runs a risk, and we'll get into that risk a little bit in a few minutes also. Even though 9602 prevents certain provisions from being varied or waived, there are some that can be varied or waived explicitly. Section 9624 contains a short list of provisions that can be waived or varied by the obligors, but those are all post-default. So again, in drafting up front, you cannot have those things waived, even though 264 allows them to be waived after default. Now, what's the list? in 9602, it's long. It is most of Part 6 of Article 9, and it is a lot of Article 2 of Article 9, Part 2 of Article 9. So it's too long to go into here. You'll need to reference it, but be aware of it. Now, even though 602 prohibits a secured party from requiring variance or waiver, 9603 allows the parties to establish standards in the document for fulfillment of their obligations. What that allows each party to do, secured party and the debtor, is to say, yes, we recognize that we have rights and responsibilities, particularly responsibilities under Article 9, but we are going to establish the threshold for what constitutes fulfillment of those responsibilities. We can make it high, we can make it low. Secured party, of course, wants to set it as low as possible. So, for example, the secured party's got obligations with respect to collateral that it has in its possession, to care for it, to make sure it doesn't deteriorate, those type of things. And the secured party can set the bar low in its documents about what constitutes proper care of the collateral in its possession. Does it mean you've got to polish it every day, or does it mean you can keep it in the same manner that the debtor kept it when the collateral was in the debtor's possession? All those things are subject to negotiation and drafting. The next item that you should consider varying to the extent that you can, or defining to the extent that you can, is what behavior and what conduct under the security interest and the security agreement is commercially reasonable. Commercially reasonable is the mantra that you will hear throughout Part 6 of Article 9 and throughout this talk. So we're going to get into that in excruciating detail a little bit later. The final thing that I think a secured party should consider, especially given the gist of this talk, which is the intersection of real estate and personal property, is whether to use Section 9604 of the UCC. Under Section 9604 of the UCC, if the same security agreement covers both real and personal property, when time comes to enforce as against the personal property, the secured party has the option either to A, proceed to enforce under Article 9, just like a regular security agreement, or B, to enforce along with the real estate under the foreclosure laws applicable to the real estate. And if the secured party chooses B, then the rest of Part 6 of Article 9 does not apply at all. So remember, we said in 9602, you can't waive or vary anything. Not exactly true if you're using 9604, because if the secured party chooses to proceed against the personal property in the same fashion as the real estate, that wipes out all of Part 6 other than 9604. Very useful. I'm a big believer in it, and I'm a big believer in it in the context that Jen was mentioning, the turnkey sale. Think in particular of a property like a hotel, where the personal property that is inside the real estate is integral to the successful operation of that building. Sometimes a restaurant, sometimes an industrial piece, sometimes a medical office building. If it's beneficial to sell that thing and maximize the price because it's turnkey, 9604 is what you want. However, it's got to be done correctly. And here I'm going to digress a little bit and refer you to a case. It was a case that was decided in 2015 by the United States District Court in the Eastern District of Virginia. I'm not going to give the style of the case because it's quite possible that some of the folks that were involved with it are on with us today, but I will give you the site. The site is 2015 WL 34047. That's WL 34047. In that case, a commercial lender made a loan to an owner and operator of a hotel. There were over 24 personal guarantors of the loan. The loan was secured by a deed of trust, and the deed of trust, like many deeds of trust and mortgages, had a small paragraph in it that said it also constituted a security agreement as to all fixtures, equipment, and other personal property located on or attached to the real estate. In addition to the deed of trust, they had a traditional Article 9 security agreement, and the description of the collateral in that document was as long as your arm. It had a comprehensive list of all tangible and intangible personal property, including books and records, inventory, accounts receivable, proceeds, everything that was beneficial in operation of that hotel, listed in excruciating detail in the security agreement. The loan went into default. The bank directed the trustee to do a single sale under 9604 of the UCC because it was more efficient. And the sale took place. The third party eventually bought it, and I think began operating the hotel. Then the bank turned to the borrower and the guarantors, because as we know, after enforcement sales, a deficiency often remains, and sued them for the deficiency. And they threw up an immediate roadblock that threw a monkey wrench in everything by saying, we don't know what you sold, so we don't know what the deficiency is. We don't know whether you sold the little Post-it note description in the deed of trust or the laundry list description that was in the separate security agreement. And since we don't know that, you are not entitled to summary judgment, which is what you're asking for. And we need to go to court to fight over what deficiency there is, if any. So I don't recommend that case because it is a leading case or because it's a seminal case, but I do recommend it because it has a detailed and readable explanation of how to use 9604 and what can go wrong if you don't do it right.
Hey, John, now that everybody knows what that case is a good reference for, can you repeat that site?
I will. 2015 WL 34047, a Westlaw site. I don't even think it's reported in the Southeast Reporter, but again, it's so well written that I think it's a good primer on 9604. Okay. Once a secured party has understood its rights and laid the proper foundation in its documents, the question is, how is it going to enforce against the collateral? If we could have the next slide, the first step in that is to corral the collateral. Personal property is inherently movable. By nature, it's movable. So it can be sold, given away, destroyed, hidden, allowed to perish, or otherwise made unavailable for liquidation and turning into cash to apply to the debt that it secures. Article 9 recognizes that, and in 9609, it states that after a default, and sometimes before a default, if it's set forth in the security agreement, the secured party can require the debtor to assemble the collateral and make it available to the secured party at a location chosen by the secured party that is reasonably convenient to both the secured party and the debtor. So make them gather it all together, put it in a place where the secured party knows that it's secure and won't walk away. Another method of controlling that collateral is to take possession via a judicial process. If your jurisdiction has a seizure or attachment procedure in court that can be utilized, you can gain possession of the collateral that way. The third method is to take possession of the collateral without judicial process, to repo it, if that can be done without a breach of the peace. The Article 9 allows that as well. And then finally, the secured party, again, without a breach of the peace, can enter onto the debtor's premises and render collateral unusable or immovable so the secured party knows where it is when enforcement time comes. Now, as to those last two self-help type remedies, this is where we need to go back and talk about putting the parameters in the security agreement in the first place, because these are simple statements. You can enter the property and repossess if you can do it without a breach of the peace. But what does that mean? Can the secured party charge in during the business day and start grabbing stuff off the shelves? Or do you need to set time, place, and manner restrictions on how this entry and repossession can be done? I think you'll find that the more reasonable time, place, and manner restrictions you have, the more likely it is that the repossession is going to be considered commercially reasonable, and the less likely it is that it will be done without a breach of the peace. On any repossession remedy, another good idea, I think, for secured parties is to obtain, either through a landlord's lien waiver or some other agreement with the landlord, the right to go onto the landlord's property, because it's not just the tenant necessarily that has a right to stop you, the right to go onto the landlord's property to corral that collateral and remove it. You sometimes will run into resistance from landlords because many jurisdictions like Virginia have landlord's lien provisions, and they're often reluctant to give those up. But it's worth negotiating up front so you're not blocked from trying to repossess that collateral. If we can move to the next slide, please, because that covers what the rights are as to tangible personal property. As to more esoteric property, Section 9607, again, allows the secured party to notify an account debtor or other person that's obligated on the collateral to start making payment or rendering performance directly to the secured party. The secured party can apply that balance of a controlled deposit account to the obligation that's secured. And then if the deposit account is maintained in a financial institution that's different from the secured party at least can stop the financial institution from permitting withdrawals from that account by immediately notifying them that there's an issue here. Don't make those payments to anybody else. Don't allow anybody else access to this account. And then, if necessary, follow up with a demand that says, now you pay everything in that account over to me for application to my debt. So those are the methods provided by Article 9 to keep the collateral from being frittered away as you prepare for enforcement. Next slide, if we could, please. In order to enforce, and when I talk about enforcement from this point forward, I'm going to talk about the most frequently used method, which is disposal of the collateral, sale or other disposal of the collateral to recover cash to apply to the debt that's secured. That process begins with notice. Under 9611, a secured party that disposes of collateral has to provide a reasonable authenticated notice. I think everyone knows that authenticated under the UCC means written and signed, a notice of disposition, unless the collateral is perishable, the collateral threatens to decline speedily in value, or the collateral is of a type that's customarily sold on a recognized market. A word on a recognized market under the UCC, that is a very narrow term. Under the UCC, a recognized market is one in which there are standard price quotations for fungible collateral. So it really narrows it down to things like stock markets. So that doesn't happen very often. Perishable and threatens to decline, that does happen. But unless you're one of those three categories, a secured party that is enforcing and disposing must provide a notification of disposition. The next slide, if we could, please. So who gets a notice? Who gets the notice of disposition? 9611 is what governs that. And under 9611, there are three categories of party that are entitled to a notice of disposition. The first is the debtor, the party that provided the collateral. The second is the secondary obligor, which is a guarantor in UCC speak. The UCC does not require the obligor, the primary borrower, to get notice of the disposition, which may seem odd. Sometimes the borrower and the party that provided the collateral are different parties. So why shouldn't the borrower get the notice of disposition? There is a lengthy explanation in the official commentary to Article 9 that tells you why, but I ignore it. I don't think it costs any more money, hardly, or any more effort to notify the borrower at the same time that you're about to dispose of the collateral. Again, it's cheap, and you prevent the borrower from complaining later, well, I didn't know what was happening. I would have changed my behavior. I would have made this deal or that deal if I had known. None of that nonsense, even though the UCC doesn't require it.
It's not a commercial reasonableness thing to let the borrower know, but I think in your experience and mine, it's a best practice to let them know, because they might go find the money to fix the issue or otherwise address the problem.
I definitely agree with that. So there's no reason not to, in my opinion. But
Because I think the name is confusing. A notice of disposition is actually a notice of like forthcoming disposition. It's not a notice that it's already done. This is
that
letting
has
people
happened.
know this is going to happen.
That's right.
So it can still be stopped, or you can still have phone calls and people can, make arrangements as necessary based on the notice.
Right. So the third category of party that is entitled to a notice of disposition is certain competing creditors, as I've said. The first type is any secured party or lien holder that gives the secured party notice of its competing claim prior to the notification date. Now, the notification date means the date on which the secured party sends the notice of disposition to the debtor and the secondary obligor. So that is your measurement date for a lot of purposes under 9611 and 9612, the notice of disposition. If the secured party gets a notice from somebody prior to sending that notice that they have a secured claim, they get a notice of disposition. The second category is the most frequently encountered category, and that is parties that have a UCC security interest or a lien on the collateral 10 days or more before the notification date that is secured by the filing of a UCC financing statement that properly describes the collateral, properly names the debtor, and is properly filed in the proper filing office for that type of collateral and debtor. So what that means is, prior to sending a notice of disposition, it is always a good idea, and well, I won't say the word malpractice, but it is required, in my opinion, that you go get a UCC search to determine whether 10 days or more before your notice of disposition, somebody else held a properly perfected security interest in that collateral. And if so, that person gets a notice of disposition as well. What that also means, though, is what happens if your sale is postponed? What if your notice of disposition goes out and your notification date is October 1, 2024? But for one reason or another, you don't actually sell until December 1, 2024. Can you rely on a UCC search looking for things 10 days before October 1? Or should you bring that UCC search forward to see whether anybody else has claimed an interest? The answer is B, in my opinion. You really should move that forward. Doesn't cost much to get a UCC search done in most jurisdictions, and it does not cost much to duplicate the notices that you already had sent to everybody else and put a new addressee on it.
You have it scheduled for October 1st, you postpone it. It's 10 days before that sale that you're going to do the check, or are you going to do it 15 days out so you can give that creditor 10 days notice?
It's the latter. I'm going to do it as early as possible that I can, within reason. If I know that my new target date is December 1, I'm going to start counting back from that and see whether I can notify everybody properly in time for the sale. But not doing it, again, you run into the same problem that we were discussing before. What if the borrower says, well, I went out or the debtor says, I went out and I got new funding that's going to help me address my problem and address your loan. And now you swept the collateral out from under that white knight and my plans are ruined. So that's the type of thing that you are avoiding by updating that UCC search. And then the third category of competing claimant that's entitled to a notice of disposition, if we could move to the next slide, please, is a creditor that has a security interest or lien that is perfected under a statute that is not the UCC, either a federal statute or a state statute, such as on the federal level, the system for recording liens on aircraft. If your collateral is aircraft, you need to check that. But more commonly, much more commonly, is state certificate of title statutes, such as Virginia's, which state that you have to note a lien on the actual title for it to be perfected. So if one of those exists, again, 10 days before the notification date, that party is entitled to a notice of disposition as well. So make sure that when you have that type of specialty collateral that is perfected by means other than the UCC, you check those as well. And then as an overarching comment on all of this, I'm going to tell something that Jen knows already, which is that when giving notices of disposition, I like to overshare. I like to give notice to anybody under the sun that I can figure out is remotely connected to this collateral. I don't think it hurts anything. I don't think it is commercially unreasonable to do that. I don't think it's very expensive. And sometimes you can ferret out things that you did not know existed by...
You might get some confused phone calls of people who do not understand why they're getting a notice, but generally speaking, the notice you're sending out actually has all the information that they need if they would read it.
Right. So, for example, I've done that to local governments or liens on delinquent taxes and that type of thing, or delinquent utility payments, just to put everybody that I can figure on notice that this is about to happen to property that they may have an interest in. Minimize the complaints later if you can. So when must you give the notice of disposition? Well, under 9.612, a notice of disposition is timely if it is sent after default and at least 10 days before the earliest time of disposition that is set forth in the notice. So 10 days, you send a note again on October 1 is your notification date. The disposition cannot be any earlier than October 11. 10 days at least. What should the notice of disposition look like? Fortunately, Article 9 provides the forms for you to look at. Section 913, pardon me, 9613 is for non-consumer transactions. Section 9614 is for consumer transactions. I don't use that one in my practice, but I do use 9613. What I will tell you is that both of them are bare bones. They're very bare bones. They don't provide anything other than the minimum amount of information. I utilize 9613 as the base document, and then I insert a lot more information to impart knowledge on whoever is getting that as to what is about to happen. And the way I ordinarily do that is I take a copy of the advertisement that I'm about to run in the local newspaper or wherever it is likely to gain the most eyeballs, and I attach it as an exhibit to my notification of disposition. And that is because the advertisement is going to contain a lot more detail. It's going to tell about what is being sold, when it's being sold. It's going to have parameters on what warranties are going along with the sale, or what warranties are going to be disclaimed, the type of due diligence that the bidder needs to do, what a qualifying bidder means, the increments of bids that will be accepted, all that type of detail, as much as I can fit into a advertisement that's not going to be 2 pages long and cost $10,000, I try to put in there, and then I slap it on the notice of disposition and send it to everybody. That gives everybody, I think, a fair chance to determine whether or not they want to bid on this property or come in to protect their rights. Now, the final notification that you have to give is if you are going to accept the property in strict foreclosure, as we talked about earlier. That's governed by section 9620. In order to strictly foreclose, you've got to get the post-default agreement of the borrower that can happen, or the debtor, I should say, that should happen. And you also have to obtain the consent of competing creditors, those competing creditors being the same ones that were entitled to notice under 9611. And we may be at are we at a
One
polling
more. One
time?
more. Oh, we can do it now. That's fine. So everybody can see your polling question. Do you see the real estate market strengthening with the cutting of interest rates? Everybody, if you want credit for today, then you need to be answering this poll question. In case you were looking at something else, we just want to make sure that you're aware. If you want credit, you need to answer now.
And the last one to respond has to listen to us talk for another hour.
Yeah, we're doing a bonus session for those who don't answer. All right. You've got 10 more seconds. All right. So the question is, do you see the real estate market strengthening with the cutting of interest rates? 53% of you say yes, 7% say no, 32% say not yet, and 9% say more softening to come. All right.
All right. Okay.
Next slide, right?
Notices have been given, everybody's been informed, and now it is time to convert the collateral into cash by disposing of it. That is covered by 9610, probably the most frequently cited in the cases, provision of the UCC, which says, after a default, a secured party may sell, lease, license, or otherwise dispose of collateral in its present condition or after any commercially reasonable processing or preparation. The secured party can dispose of the collateral in public or private proceedings by one or more sales or contracts, as a unitary whole or in parts, and at any time and at any place on any terms. The secured party can also purchase the collateral at a public sale and sometimes at a private sale, but again, only if that is property that is customarily sold on a recognized market. So 9610 gives the secured party pretty wide discretion on how to dispose of the collateral until you get to the but. And the but in section 9610 is that every aspect of a disposition of collateral, including the method, manner, time, place, and other terms, must be commercially reasonable. That, again, is the hallmark of a disposition or other enforcement under Article 9. If we could go to the next slide, we'll see that section 9627 provides limited examples of what is a presumptive commercially reasonable disposition. Those apply on narrow recognized markets, but also a presumably and presumptively commercially reasonable disposition is one that is approved by a court. If a court approves it, it is automatically commercially reasonable. A commercially reasonable disposition also includes one that is approved by a creditors committee or by an assignee for the benefit of creditors. Those pre-sale or pre-disposition approvals render the disposition commercially reasonable. Outside of that short list, though, what constitutes a commercially reasonable disposition is decided on a case-by-case basis. So what is commercially reasonable then for these purposes? In general, a commercially reasonable disposition is one that is designed to achieve the maximum realization on the collateral for the benefit of all concerned parties. In other words, maximize the price. But price alone is not determinative. 9627 also says that the fact that a higher price could have been obtained by a sale with a different method, time, or manner than chosen by the secured party does not in and of itself render the disposition not commercially reasonable.
So to me, John, in a bankruptcy context, bankruptcy judges love an auction because you advertise it, lots of people show up, and they basically set the price. And I guess that makes sense for a business or a building. But when this makes me think that last provision you just read, you can't always have a measured value. There's a blue book for XYZ business, but I have seen with equipment, gosh, if we'd sold that bulldozer 6 months before, it would have achieved X price. There is a variability for things like that. So I think that provision is important and protective. And I have seen huge swings in the value of pieces of equipment like that can have kind of a blue book value. So it's nice to have that protection. But when you're selling something that there is no apple to apple comparison, courts like that marketed process and an auction process because it sets that market value. I think that's a pretty important thing.
Okay, and we've got the roughly 10-minute warning, so we're going to step on the gas here a little bit. But I'm going to tell you the horrible that can happen if your sale is not commercially reasonable. It's not actually in the slides, but it appears in section 9626 of the code of the UCC, and that is this. It concerns the deficiency. Again, we mentioned that most sales result in a deficiency. What 9626 says essentially is this: if the sale is commercially unreasonable, then the amount of the deficiency is going to be limited to the difference between the total debt, principal, interest, collection costs, everything, and the amount that would have been obtained if the sale had been conducted in a commercially reasonable manner. So you can see right away there's plenty to fight over of what would you have obtained. What's worse from a secured party's standpoint is there's a rebuttable presumption that what would have been obtained in a commercially reasonable sale is exactly equal to the total debt, principal, interest, late charges, everything. So as a practical matter, it wipes out the deficiency unless the secured party rebuts that presumption successfully. That was the gist of the hotel case that I was talking about earlier. There was a $6 million deficiency. The bank sued for it. The borrower and the guarantor said, oh no, this was commercially unreasonable because you sold under your deed of trust this big long laundry list of things that weren't listed in your deed of trust. Therefore, everything that was sold under this laundry list was done in an commercially unreasonable manner, which lets us off the hook for the entire $6 million deficiency. Wasn't decided in that case, but if it were, that's a bad day for the secured party and a great day for the borrower and the guarantors. Next slide, please, real quickly. If a commercially reasonable sale occurs, the effect of it is to transfer to a transferee that is in good faith and for value all of the debtor's rights in the collateral that was sold, cuts off the debtor's vesting, to discharge the security interest under which the sale was made to the extent of the collateral disposed of. Don't let go of anything that you didn't already actually sell, and to discharge any subordinate security interest or other subordinate lien. That wraps up the sale aspect of it, except to note that in the next slide, the successful enforcement also requires the secured party to respect the debtor's rights. It's not only commercially reasonableness, it's not only 9602 not waiving or varying provisions. There are other rights that a debtor has, and those are mainly set forth in 9623. The debtor can always redeem the collateral right up to the moment of disposition. So can another secured creditor if they follow the hoops. And post disposition, especially in a consumer case, but sometimes not in a consumer case, detailed accountings of what happened and what was sold and for how much need to be provided to the debtor as well. So with that, I'm going to turn it back over to Jen unless we have another.
I think we have another poll question. All right. What sector of real estate is most vulnerable right now? Warehouses, retail, commercial office, personal homes. Again, there's no right answer, just interested in your thoughts. If you want credit for CLE, you need to fill this out. You still have time. Have about 30 seconds. We won't keep you for too much longer after this either. All right, last 10 seconds if you haven't answered yet. And if you want credit, we need you to answer. All right. So apparently people do not think warehouses are vulnerable. I tend to agree. I think they're all full of stuff from Amazon. Retail, 17%, commercial office, 75%, and personal homes, 6%. Thanks for sharing your thoughts. Okay, so we're going to skip ahead to the slide that says foreclosure processes. So we've talked about all of these things that we have to do, the notices, commercial reasonableness, and that's all governed by the UCC vis-a-vis the things that might be on a piece of property, that might be someone's collateral. Depending on your state, the foreclosure processes, where if you're going to sell the home where these things are, or the office or the hotel where the personalty is located, can be done in some states through a judicial process, which is commenced with a lawsuit and where the property is sold if there's no payoff that comes in after notice. Statutory or power of sale is the other way to conduct a foreclosure. Those in states that do not require the judicial process, and that's based on the loan documents and the state statutes. So sorry. So if we're going to use the statutory or power of sale, the courts do not get involved. There may be a commissioner that does an accounting at the end, but you are doing a notice, much like John's process that he just discussed. You're going to do a notice of junior creditors. You're going to do a notice, in this case, always to the borrower, because they may want to correct things. And then you have a waiting period. As it says on the slide, in Virginia, for a commercial property, the non-judicial proceeding is 14 days. That is intimidatingly short, I think, to some folks. There's almost not enough time to figure out what you're going to do with the property if the bank or lender is going to credit bid and take the property back. People need more than 14 days notice to really take something back, including understanding environmental risks and things like that. But also think about all the deadlines that John just said. 14 days notice is really not enough time to even think about getting all of your notices, your 10-day notices out. It actually is enough time, but you really have to be on your game to make it all happen. And Article 9 wants 30 days notice under certain circumstances. So in Virginia, residential property requires 60 days notice. That is really to give a consumer more time to try and work something out or potentially refinance. If someone has submitted a foreclosure and started that process, that is not a ding on your credit. Maybe the slow payments or no payments or things before would be a ding on your credit, but just getting a foreclosure notice isn't necessarily going to eliminate your ability to go refinance out. You know, if your loan came due or there was some other process, you lost a job or something, if you can get back into good standing, you may be able to refinance out of foreclosure trouble. And there's certainly enough time in the 60 days notice there. But if you end up filing a bankruptcy, it's almost impossible to refinance. Banks require so many extra hoops once that's in place. Just something to keep in mind. In DC, just for kind of covering the footprint that we're covering today, DC has a judicial and non-judicial foreclosure available. It's supervised by the mayor and it's kind of paternalistic. North Carolina is non-judicial foreclosure. South Carolina is judicial, and in Maryland, it's non-judicial but ratified by the courts. I would just say, again, to the notice of when you're talking about dirt, you're talking about land, there may be judgments that have been recorded against the land, so that's going to be different than the UCC concerns. There may be mechanics liens and second mortgages, so you're also going to send notices again to all of the people. You're going to want to run title and a UCC search and give everybody notice of what you're doing. Once you've conducted your foreclosure sale, there is a limited time for the buyer to move out. different from the redemption that John was talking about for UCC, where the debtor can get back in good stead and correct. Under South Carolina law, when you're talking about a foreclosure, there is no equity of redemption. The borrower can bid at the auction. In Maryland, there is redemption rights for foreclosure up until the day before. In Virginia, up to the start of the sale. In DC, it depends. Commercial versus consumer have different, again, that paternalistic process where they're trying to protect consumers. And in North Carolina, up to 10 days before, they have to pay off the loan and all of the costs. Next slide. So remember back at the top, we were talking about receiverships. I think it's worth noting that the Uniform Commercial Receivership Act has been passed in North Carolina, West Virginia, and Maryland. It is pending in DC. So that means just like the UCC, there's a set of uniform rules related to receiverships in those 3 states and soon to be in DC as well. South Carolina and Virginia have not adopted the Uniform Commercial Receivership Act. I'm going to talk about the non-uniform because that's, I think, where it's most interesting. Just to generalize, receivership laws like Virginia and South Carolina have basically say you can have one. And then you're back on your loan documents talking about what rights to a receivership and what that threshold was. To John's point earlier, if you have negotiated what the trigger for a receivership is, it makes it all the easier for a court. But generally speaking, if you've got enough defaults or you have enough distress on the property, no circuit court judge is going to sit there and say, I'm sorry, no receiver, this just feels unwieldy. When a property owner doesn't have insurance or the apartment complex no longer has a manager, all things like that, judges want to preserve property, human life as necessary. So you're not going to get a receiver appointed because there's a plain old regular payment default under the note, under the deed of trust. But if there are bigger things going on, a receiver is a great remedy. Receivers can run healthcare facilities, they can run a manufacturing facility, they can run apartment complexes. And it's where there are, oh goodness, I'm going to skip right through. I'm just being alerted the fact that I have only a minute. So receiverships, again, as indicated at the top, where there's a business to save, we usually run a receivership to save the business and get it to a sale process. And in that case, the receiver is going to be the one sending the notices and doing all of the things that John and I have talked about. The next slide is assignments for the benefit of creditors. I think I just want to reiterate here, this is basically where the borrower is throwing in the towel and saying, I don't think I can do this anymore. And then the assignee will either sell the pieces and parts if there's no going concern value, or if it can be held together and a sale can be noticed very quickly, then the assignee can do that. An important thing that I think is worth considering here is that when you have an assignee, they're going to observe all of the fiduciary obligations of the officers and directors, which is very favorable. When everything is kind of melting, that melting ice cube is happening very quickly, putting an assignee in place is going to make sure that everyone feels like their rights have been preserved and protected. I have a number of additional slides, but we are out of time. And the last thing I want to do is be between anyone and their lunch. And we're grateful that you joined us today. And we are, come back for more this afternoon. And John, thank you for working with me on this. It's been a pleasure.